Today, we're going to do a little bit of discussion about how Level Insurance application works, how simple it is. So this is going to be a quick explainer video for all the lawyers that are interested in buying Level Insurance. Very briefly, though, Larry Basuk and I invented Level Insurance as trial lawyers with the sole purpose of being able to give plaintiff lawyers the ability to mitigate their risk. As Larry once came to me a long time ago when I was practicing on my own, asked me, is there any way that you can protect yourself in the event that you lose your case at trial? My answer was not as it relates to my time or my fees, but maybe there was a way that we could protect the risk of advancing the cost. And so he and I came up with what we originally called litigation cost protection, which we now call Level Insurance. So we're going to talk a little bit about the way this works. I have my iPad here in front of me, so what I'm going to do is going to come off camera and show you the way that the application works.
Yeah, I think what's interesting is not only did we invent this coverage, but during the process we invented, I think, which is a pretty cutting edge way of buying the insurance itself.
Tell us about that.
Well, that was part of our whole vision, was to make this a simple process, to make it something that's intuitive. And we know from experience how difficult it is to be a practicing attorney, be running your business at the same time. So whatever it is, it had to be simple. It had to be straightforward. So we invested a lot of time and a lot of effort developing this platform to make it very quick.
And that's the thing, is that when you buy insurance, whether it's homeowners, auto, jewelry, anything, insurance companies are constantly looking for ways not to pay claims. When we started this program, there was one purpose and one purpose only, was to make sure that we were giving our clients, who ultimately were our colleagues, exactly what they were paying for. There is no red tape. There are no crazy exclusions. If you buy Level Insurance and you lose your case at trial, you will be paid all of the money for your case expenses up to the limits you selected without questions being asked. There's not going to be an adjuster asking you whether the neurosurgeon that you hired was too expensive or whether the travel that you took was necessary. You are the lawyer who is in charge of your case. You are the lawyer that is in charge of your expenses, and that's the way this insurance works.
And that philosophy starts at the very beginning, as you're going to see. We're not underwriting the merits of the case. We're not looking into it. We're not asking you what your litigation strategy is, nor do we have any business getting involved in that. As you'll see, these are very basic questions, mainly gathering information. You can buy the policy in a matter of minutes.
So, switching over to the policy, now we're going to show you the screen. So the first thing that you need to do is go to levelesq.com, levelesq.com. And when you get there, you're going to be met with a screen that says protect your investment and stop being the bank. And there's two areas that you can click on. The first is Level Insurance. The second is Level Case Financing. We'll be doing a second video discussing Level Case Financing. For right now, we're focusing on Level Insurance. So you click Buy a Policy. When you click Buy a Policy, it takes you to the screen to get a quote. So to get a quote, you click on the state, and I'm just going to click on, a random state. I'm going to click on Virginia, because in Richmond, Virginia is where our home office is, besides being in Miami. And then you can start entering information. You enter your first name, then your last name, then your law firm name. I'm just using our law firm name for just ease of use. You enter the address of your law firm, and we use Google Maps, so it automatically will pick up your address. You enter your phone number next. All this is just personal information needed to capture in order for the policy to be bound. And this is probably the longest part of the entire application, believe it or not. Because as Larry said, we're not underwriting the merits of the case. We're only asking you for information to allow us to underwrite the case very, very simply. So just finish up here, hit continue after you've entered your information. All right, so now when you get to page 2, it's asking you for case information. So the first thing you need to do is fill out the name of your case. I'm just going to use Smith v. Jones, just basics, but you're going to put in the name of your case.
Yeah, this doesn't need to be the full case style or anything like that. Just whatever you refer to as Smith v. Jones. It can be abbreviated.
Right, because as you'll see, we're going to eventually have the complaint, so we'll have the full case name. You then select the case jurisdiction. The reason we ask for case jurisdiction is it's possible that your office is in one place, the jurisdiction of the case is in the other, so we're just asking for that information. Then, as you'll see, there's an area where you can either click to immediately download a PDF of the complaint, or if you don't have it, or you want to provide it later, or you're not tech savvy enough to figure out how to download something from Adobe onto the website, you just click, I'd like to email my complaint file separately, and you'll be able to do it at another time. The next area is the date the complaint was served. And why is this important? Because you have to buy the insurance within 120 days of serving the lawsuit on the defendant. Not filing the lawsuit, but serving. So it does give you a little bit more time to make your decision beyond the date that you filed it. So we're going to ask you the date the complaint was served, and the embedded calendar here will automatically be able to identify if it's outside the 120-day period of time. If the complaint has not yet been served, there is a box that says not yet served, which for purposes of this demonstration, I'm going to click on right now. It then asks you the case type, and it gives you a number of different case types, and then there's the catch-all of other negligence, so you can just select the case type. All of these case types are able to be bound with insurance. We just collect this information to try to see what type of cases we are insuring. And then the policy limits. The policy limits can be any number that you choose between $3,500 and $250,000. We did write up to $500,000, and we think that will happen again. But with some of the economic changes that have occurred, we've lowered it to $250,000 temporarily. But right now, you can go up to $250,000, and you can choose any random number. It doesn't have to be in a $10,000 or a $25,000 or a $50,000 increment. You just budget whatever you think the case is worth, and you write the number in. So for purposes of ease, I'm just going to put $100,000.
But again, keep in mind, this is not. This question is not meant to be what's the insurance policy limits on the defense side. This number, the policy limits you choose, should roughly correlate to what you think your litigation budget would be if you were to try the case.
And it's possible that you will overinsure, and it's possible that you will underinsure.
And some people do that intentionally.
Right. It depends on what your appetite is for risk. Typically speaking, we find that claims that come in are very close to the amount of insurance. But more importantly, if you, let's say, have a $100,000 policy and you've spent $65,000 or $70,000 when you get to trial, you know you have that extra $30,000 covered, which gives you the opportunity to go spend additional money on things that are more luxury items that you may have questioned whether you wanted to spend if you weren't insured. Things like focus groups, extra trial technology, things that would be a little bit more expensive, but now you can actually enhance the presentation of your case because you've saved a little money through what is left on the insurance. So that takes us to the next page, which is optional coverages. About 3 years into this program, we added a rider, which means an additional coverage that you can purchase for legal fees. Because as you know, if you lose your case at trial, not only are you not going to get your costs back if you don't have insurance, but you're also not going to earn any money, any fees. So we developed the opportunity for you to buy as an additional part of the policy coverage for a portion of your fees. And so how does this work? In this example that I'm using here, it was a $100,000 cost policy, which gives you up to $20,000 or 20% available in fee coverage. The fee coverage costs an additional 10% premium, so it'll be another $2,000 if you choose to buy it, on top of the 7% premium that you pay for the level insurance cost coverage. And then if you lose the case at trial and you've spent $100,000, you will have $20,000 sent to you in a check for your fees.
On top of the $100,000 you're getting reimbursed.
But keep in mind, you get the 20% up to what you actually spent. So if you bought $100,000 in coverage and only spent $50,000, you're going to get $10,000 in fee coverage. Reason being is that we can't allow folks to buy $250,000 in cost coverage for a case that only has a $25,000 budget for costs, so they can collect $50,000 in fees. That wouldn't be reasonable. So we limit it to 20% of what you actually spent, up to 20% of the fee cover of the cost coverage itself. For purposes of this example, I'm not going to select it. I'm just going to hit no, and we'll move on to the next, which are the applicant eligibility questions. The first question: has the first chair attorney, other attorneys, or plaintiffs been found in violation of Federal Rule of Civil Procedure 11 or its state court equivalent? If you answer yes to that question, it will not automatically mean that you won't get coverage, but it will trigger additional underwriting questions that will come later. But for purposes of this demonstration, I'm just going to answer no. The second question: have any of the attorneys representing the plaintiffs been disciplined by the bar of any state in the previous 5 years? Same thing as the first. It's less likely that we'll be able to approve you if you've been disciplined, but if the disciplinary reasons are non-financial, they were short-term or a longer time ago, it'll trigger additional underwriting, and it's not automatically disqualifying. But of course, it's always better to answer no, if that's true. The third question is this case seeking damages from either a distributor or manufacturer of any type of tobacco product? We do not cover tobacco-related items. So if it is a case involving litigation against R.J. Reynolds, Philip Morris, or any of the other tobacco companies, or in any way involves that, we will not be able to insure it. If the answer to that question is yes, it will kick the application out automatically and it will not be insurable. So I'll answer no here. The fourth question is a question that was put onto the application at the time of COVID-19, and it was really to prevent the onslaught or what was thought to be an onslaught of business interruption cases. It really isn't relevant anymore, and I've never had somebody answer yes to it, but it's just asking if any of the claims asserted are first-party claims against an insurance carrier related to damages from COVID-19. So I'll answer no. If it's yes, it's not coverable, but again, it's something that we haven't seen.
It hasn't happened once.
And we don't anticipate to be an issue. And then you hit continue. Once you hit continue there, you get to the end of the application, and it gives you a breakdown of the cost of the premium, the state-related taxes and fees, and you can pay it either immediately right there online by selecting proceed to payment, or you can select to pay it over time through a third party that we use that does financing. From my understanding, although we don't do the financing ourselves, you have to put either 20 or 25% down, and then you make 8 payments over time to finalize the payment for the insurance.
Yeah, and if you decide to pay for it in one installment or in one lump sum, you can use your credit card, which most of our customers choose to do, or you can schedule an ACH debit from your operating account. So we give three ways in which you can pay the premium online.
And the moment that you pay for it, you will receive an email with a copy of your policy. And if you're using a desktop, the policy will download automatically as an Adobe PDF to your computer. You then put the policy into a folder, and in the event that you lose the case at trial, you will then have this policy available to you to get reimbursed. I do want to talk for a moment, now that we've gone through the application and we're back on camera talking with Larry and me, a little bit about ways that people use this insurance besides just for risk mitigation. Because the obvious use case is to protect your costs. That's exactly what we developed it to do. But of course, as you're utilizing a product and as we've been selling the product, we hear from our clients other ways in which they've used this insurance to better their practice. Larry, maybe you can talk a little bit about some of those items.
Well, we always thought that this could also be used to enhance somebody's bargaining position. I mean, it's not a coincidence that we named the product Level. And we've gotten reports from a lot of our clients throughout the country that when they go to the bargaining table, when they go to a mediation, or maybe if they're on the phone with opposing counsel, at a certain point, they'll let them know that they have this coverage in place. And they'll say, for example, Mr. and Mrs. Defense Counsel X, here's my deck page for this policy. I've got $200,000 of coverage. If I were to try this case and lose, I'm getting my cost investment back. That's changing my thought process now. That's making me feel more confident. That's making me less susceptible to pressure from the defense to settle a case for an amount less than I think it's worth, because they know I may be anxious about spending another $100,000 to try the case. This removes that from the dynamics, and we've been told by many of our clients, as we suspected, that it actually has the effect of enhancing the value of the case, of facilitating resolution, which of course at the end of the day, if you look at it from an economic perspective, the ROI, the return on investment from a premium can be multiples of that initial premium amount, because you're enhancing the value of the case and you're getting it resolved more quickly. So that's been a really exciting thing for us to hear from a lot of our customers.
And one additional item of importance is that Larry and I are both lawyers in Florida, and we were able to get a Florida bar ethics opinion, which has been replicated in North Carolina and Utah, which says that you can pass the premium of Level insurance onto your client as a reimbursable case cost in the event of settlement. So what does this mean? If you have, and by the way, although it's only those 3 states, lawyers throughout the country have used those opinions as support to do this in states all over the United States, because it's a sound bit of reasoning from the Board of Ethics in each of those states. And all it really requires is notice to the client in the contract. And lawyers have been doing that nationwide.
And we have sample language that's available on our website, or you can email us and we'll send it to you.
And so what is the effect of this? Either one of 2 things will happen if you have the insurance. Either A, you will win the case, settle the case, and that premium will go on the closing statement and you will be reimbursed for the premium, meaning that you have effectively paid nothing for it. Secondly, you'll lose the case, and if you lose the case, you'll make a claim and you will get all of your money back that you spent on the case, except for the premium. So you will win as far as the costs are concerned on both ends. It's a win-win, and in our opinion, as trial lawyers ourselves, it really is a no-brainer. It's something that you should be doing to enhance your practice, to be on the forefront of practicing law, and to really get the very best results for your clients. So if you have any other questions, please feel free to reach out to either Larry or to me to discuss. Otherwise, we hope you enjoyed the video, and we look forward to you purchasing Level Insurance policies.